if he's screaming and yelling at me and I feel like I'm like new to this, I'm clearly onto the right lane if I'm upsetting somebody.
Sometimes the moment you know you're in the right career comes in the middle of a hostile deposition. Welcome to Make Your Case, the podcast where attorneys break down the most impactful cases of their careers and the stories behind them. I'm Joe Douglas, longtime investigative journalist and founder of Clear-Eyed Media, where we produce legal videos that help lawyers win cases and reach better outcomes. Today's guest is personal injury attorney Damon Hudson. Damon shares how his time as a civil defense lawyer helped shape the way he builds trust with clients, why storytelling matters at every stage of a case, not just trial, and the deposition moment where a named partner completely lost it. Welcome to the show. Damon, if you could, please go ahead and introduce yourself, talk about a little bit of your experience and where you are.
Yeah, I'm Damon Hudson. I'm in Santa Fe, New Mexico. I take cases across New Mexico, but primarily practice up here in Santa Fe. I'm originally from Albuquerque, and I've been a personal injury attorney now for 5-6 years. And a couple months ago, I took the leap and went out on my own and started Hudson Injury Law because I like doing the work so much that I thought, well, might as well do it for other people on my own behalf. And I just have enjoyed it so much that it's gone from a defense attorney to a general practice to PI to my own firm in the last since I started practice in 2019.
Great. And so what really brought you into law initially?
Being misguided, I think, is probably not having a lot of direction. I don't know, maybe by nature of who I was as a kid, I didn't have a lot of dreams, or maybe I just liked living in the moment. So I went to high school, and I saw my friends stressing about going to college. I was like, why would I spend a lot of time on stressing about this? So I went to they call it University Near Mom, or UNM, Harvard on the Rio Grande. And I had a great time and had a lot of fun. And then I graduated and went, didn't know what to do. And I took a consultant job for an organization I was part of. And I traveled the country. And then I decided to get a master's degree. And that didn't give me any direction. And so partway through, I was like, maybe I should start thinking about my future. And I thought back to what I'd wanted to do as a kid. And that was I remember being 8 years old, jumping on my dad's bed and him asking me. And I said, well, I'd either want to be a lawyer or a football player. And I'm tall by New Mexico standards, but not tall enough to be what I needed to be. And so thinking about it, I was like, well, let me explore being an attorney. And I spent a couple months and really kind of investigated that, and then spent the next year or so taking the LSAT, applying to law school. And I jumped into it hoping for challenge, and I just loved the kind of way thinking through stuff. But I mean, I think I went in with the goal of like helping people, right? It's I don't know if that's like a millennial thing but I wanted to do what I did to help people. So I jumped into that. But when I started as a defense attorney for 2 summers and then a defense attorney my first year out, I didn't find a lot of what I was doing to be helping people. And so then a year or so after in practice, I stumbled into plaintiff's work. I was like the light bulb moment of like, oh, now I can actually do something to help people, as opposed to just me billing by 0.1 increments and putting myself in a position. I found that to be incredibly, it just wasn't for me, right? It was doing defense work was the first time I ever thought, oof, I think being an attorney was a bad idea. So kind of a roundabout way, not the craziest story, but that's kind of how I ventured into law and then ended up doing plaintiff's practice.
So defense work you're talking about. And there's the other thing I like to point out is this podcast is aimed at, there's lawyers that would listen to it, but also the general public too. So there are times when we are going to explain some basic legal jargon or concepts that might sound really like basic to you, so in defense work, are you talking about civil defense firm or criminal, or what do you mean by that?
No, that's a great point, right? I always try and be, it's always better to, I think a lot of the law is like built up on these big words, and it's a lot better to just explain things in plain terms. It was civil defense. So what I was doing is I was working on behalf of an insurance company. I think the simplest way I'd put it is sometimes it was helping some providers say they didn't kill somebody that bad or they didn't hurt them that bad. And that's kind of how it was helping the insurance company to not pay out for claims for medical malpractice was really kind of what I did. And I won't pretend that I was not good at it. And I think maybe that's because my heart wasn't in it, but it was more defending providers compared to like criminal defense, public defenders. I didn't do that.
So, and so this work, it sounds like you just didn't really like it very much. and that you were kind of part of a machine, sort of. It sounds like you were saying like you're logging billable hours, or what was it that about it more specifically that you were kind of turned off by?
I mean, I think like what I do now, I have a lot of interaction. Every day is different. I'm driving my car to a client's house. I'm doing a deposition, and maybe too, that's also having my own control over what I do. There, I couldn't. Maybe in plaintiff's work, I found that there's a lot more. When I first started a plaintiff's firm, it was like somebody needs to figure this out, and I'm busy, and you're not. Figure this out, and I was like, oh, I can just do this. Whereas in defense, because I was on a billable schedule, I had to justify the hours I spent, and I remember being like told. Comparing a document wasn't like being the titling of tasks I did. Oh, you compared these two documents. I was supposed to compare them and find the differences. And I was told that this point one wasn't sufficiently defined. And I remember being like, this is a lot of talk about not doing anything. Like I was writing briefs and motions that had been written 100 times. It just didn't feel like I was getting anywhere. And so it just wasn't, I mean, it felt so, I guess, rote maybe in what it was done. And again, a lot of the time, you're doing the same thing to try and pick one little piece out of a plaintiff's case. Whereas as a plaintiff, there's a lot of creativity, a lot of different direction you can take. You can do something that's never been done. And right, I love when an attorney says, I've never seen this before in my 30 years, because I'm like, how exciting. I get to show you something new just in a couple years of practice.
So is it like a sense of ownership that kind of invigorates you a little more?
I mean, I think the ownership, but more than anything, I mean, sure, on the side of having my own practice now. But the thing I found from starting off as a plaintiff's attorney to even now is that like one-to-one connection, right? I remember one doctor I got close with, and I think by nature of him just being a kind person, he had questions, but otherwise I didn't get to build those relationships because I would have had to been somewhere for 10 years and be doing that, and also doing the work wasn't necessarily what I wanted to do. Whereas a plaintiff's attorney, I immediately got to sit down with somebody and listen to them about something awful that happened and be there and be kind of I think of it as like the moments where I realize I'm a lawyer as counselor and I'm there to be supportive. And so having that immediate relationship shift of that connection was like really invigorating, because it's like what I went to do. I get to help people, right? These people come to me at the worst moment of their life. And sure, I feel like I'm gregarious, so it's always hard to like when they first greet me, but I always am looking forward at that moment to like, hey, I can't wait to be in a position to make this as good as possible for them, right? To help them with my skills and what I know to navigate this complex system and put them in a better position.
Great. So, and then kind of what, one of the core questions we get to here is, what's a sort of a notable case for you so far in your career that sticks out as something you either got a big win from, or maybe you didn't get a win from and it was really not great and you learned a lot from? Is there a case like that in your mind that we could talk about here?
Yeah, there's one I think of, and I think in the context of going out on my own, it's one that kind of, looking back to my early practice, it was really the first one that I got to like sink my teeth into, and one of those cases that really led to that like light bulb moment, because I was sitting there on the other end of a case against people I had dealt with before and seeing, okay, again, this is what the plaintiff side of getting to help somebody looks like. And so do you kind of want me to just jump into it?
Sure.
So it was a case about an older gentleman who he'd had a family member who had a case years before. So like first showed me, right, that a lot of plaintiffs' cases and a lot of plaintiffs' attorneys, especially in New Mexico, the job is first building relationships, right? People have to trust you, and it can't just be a lot of the time people aren't going to come to you just because you put your name out there, right? They've built that trust. And so first off, it was the first sign of seeing this case had appeared in that law firm because their prior family member had a case. And so like I knew the other attorney had been called to the bedside of one of the family members, right? They had just built such a relationship. And so that was like the first thing for me. Again, that's not happening on the defense side. And this had been within 6 months of leaving defense. So again, it's that first trigger of seeing that relational component of things. And so this gentleman was in the hospital, and providers totally misattributed he had had some mini strokes, and at the same point had totally just disregarded his heart symptoms. And so in that disregard for his heart symptoms, they had allowed him to pass away earlier. And so they had really neglected to take the care they needed to for him. And so but the case was simple and straightforward, I think, in the context of what happened to him. But me getting to see through the steps and like kind of finding my own voice and steps throughout the case was, again, the chance to do something I wouldn't have been allowed to do on the defense side, but allowed me to push into caring for this family and developing my own relationship. And so we first off, and Joe, tell me if I'm jumping ahead of you, but I'm kind of just want to go through a little bit of I got thrown in a couple months after the complaint had been filed. And so like, I think the first thing that and I don't know, maybe it's because I liked, again, having the control of how you help a case, but as a plaintiff's attorney, I found you get to have more control of what you do. So what that means for some plaintiff's attorneys is you can file a case and sit on it for 5 years and do nothing, and nobody's going to stop anything. A defense attorney's not going to generally be mad at you for that. But at the same point, if you push the ball forward, you start asking for discovery. I mean, that's the simple thing, but like you start asking for depositions, you fight over doing a deposition of the corporate entity. All of those things are initial steps you can do to really push the ball forward. And so I remember just coming to my boss being like, what about this? What about this? What about this? And it was like, okay, go ahead. And it wasn't a thing of like, we need to pull back, but it was how can we better develop our case and better put their case out there, and just finding different ways to do that. And I'll be frank, had I not had a wealth of resources of legal podcasts or books or people that I had just learned a ton from, just like driving to work or biking to work, I would have never known some of the options of what I can do, right? Like the trial lawyer listserv of people just throwing out ideas was really instrumental in me going, let me try that. And a lot of those things are, sending a discovery request is low risk, but it also indicates to the defense, we're taking this case seriously. And so it started there. But I remember like the key moment, like in a moment for me that was really key in my development, was we were doing a deposition of a corporate representative. And I was like, well, the corporate representative had signed their discovery. Let me ask them about their answers. Right? It's a fair question of, okay, you said this in paper, let me ask you about it in person. And I remember the named partner at this law firm, I was a 2-year associate who was brand new to plaintiff's work, screaming and yelling at me over a Zoom call. And I remember thinking to myself, awesome, this is exactly what I want to be doing, right? He's screaming and yelling at me. If he's screaming and yelling at me and I feel like I'm like new to this, I'm clearly onto the right lane if I'm upsetting somebody. And then too, right, it's like, it's not just for like vindictive purposes. It's, I'm going to be able to help this family get some justice for that loss. So that was like, again, that was of a couple moments, one that I went, I'm doing exactly what I need to do. And like that literally led to me doing just PI work later. But so we went from there to right, the building relationships with an expert and recognizing one of the things like a medical malpractice case, or even just you're paying somebody for that. Again, just learning from podcasts and like how to tell that story. Sometimes it's me calling this expert, and I mean, sure they're billing for my time, but asking them questions to better understand. I can't tell the story of the client's case unless I'm able to grasp it, right? I think I don't know who, it's like if you can't teach something to somebody, you're not gonna be able to tell the story. And that's like really a lot of the context of teaching. It's been a couple years, so I wouldn't be able to do it now, but teaching how this heart impact and the strokes and how the comparison between the two should have been done by a cardiologist who kind of, I think effectively in the context, really just wanted to leave work or something. I think that's what we found. And then I think even to it is I had just been hearing so much about the storytelling aspect and how we prepare it, that I was like talking to my boss at the time, I'm like, let's go sit down and build our themes, right? Like we did a lunch and kind of talked about how, I think it was the swerves from safety or something to that effect, and kind of building a theme and then starting to implant that as the case is going on, right? So I'm asking a question to a doctor in a deposition for the other side, but I'm building in these 3-word phrases that I think maybe it's not hitting home there, but if it's something that I start to say and I'm building into the story, it really just becomes a situation that putting it forward, it allows that to like build towards the case. And so those are, I think, some of the more instrumental things of going for me, like boom, boom, boom. There's so many options of what we can do, but also me running the ball down the field best helps my client's case move forward.
So you're touching on a lot of things here. So there's this sort of the sense that you got that you kind of had maybe poked the bear, or that you had touched a nerve, that your research gave you a sense that you had paid off. And then how did that ultimately bear out in the case?
So I mean, I think it's instrumental in the sense of like my learning. I think putting the corporate structure on its tail and having them, right, I mean, they're already able to indicate, they'll write this answer and verify it and legally say this is sworn, and then they have this person who's under oath swear to the same answer. you immediately have a competing answer from the same person, right? And frankly, that's probably because the lawyer told them what to write, and they have that. How that bore out here is it's like I felt so great about the case we put forward, and I think that this is like the advantage that it came to a reasonable settlement, right? Like it was able to satisfy the family. I think the defense firm was able to recognize that the case was in a good position, that it wasn't going to lead to a verdict that they were going to be happy with. And so as much as it was instrumental to me in so many different ways, but we didn't get to see the follow through of what that looked like, which is not a bad result because the client got right. At the end of the day, the client was happy with the resolution, and that's whatever that looks like. And frankly, a trial is a risk to them, right? They're putting that out there. And if they say, I don't want to risk that, and especially this family who had seen litigation before based on the relationship, they're not going to put themselves out there again, but they were happy with the resolution they were able to get. And I feel like putting in some of these steps as a new attorney really helped us to get to that point that resolved that case.
Were you like, was that like that you talk about this like as a kind of a big moment for you, which is cool, but was that something that you felt like you may not have done before? Or what kind of, was it the fact that you were invigorated by being a part of a case that you actually believed in or cared about, or was that a big difference for you, or talk about that aspect of it?
Well, I mean, do you mean like coming from the defense side about this case specifically invigorating me?
Yeah, but I mean, just there's something that seems like to really have lit up in this case for you about like in terms of like, trying new things, like you said, based on your own research and input that you're getting.
Yeah.
Yeah. I mean, what was it, or what was it different about this that kind of became notable for you?
I think it was, again, seeing that what you can do for somebody, right? Because I don't feel like when I was a defense attorney, I felt like I was righteously fighting for anybody. I didn't feel like I was fighting for anybody's behalf, right? I'm drafting a motion so insurance company doesn't have to pay. I didn't feel like I was standing up for something that I believed in or someone I could support, right? I don't think I have to believe every point that every client puts forward, but I know that when they've been harmed and I can support them, that was that in moment. I think another case I'd like to briefly touch on were two just instrumental moments for me on seeing that what I could do to stand up for somebody and kind of support them.
Yeah, I mean, that's an interesting dynamic for attorneys is you're a hired gun, but then how much does, believing in the case impact your ability to do the job? And how do you handle that tension of, I come from the world of like mostly journalism in my life. I've definitely been assigned to stories where I'm like, really, this is, it's not even so much that I think if the story wasn't factually correct, I just wouldn't do it. But
Sure.
But sometimes you do a story where you're like, this is really stupid, or this is like, why does anybody care about this? But you just got to do your job and do it anyways. How do you deal with that tension as a attorney where you may have a client or something where you're like, you're like, I don't know if I really care or believe in this, but they're writing the checks. How do you deal with that?
Well, so first off, they're not writing the checks. In the field of what I do, I'm all contingency fee based. I only take a case that I represent up front, that I put all the costs into it. Going out on my own, am I going to take the risk of making those? And so first off, when I'm talking to someone, Joe, you called me with the case, I'm thinking of, is this something that I can sell, right? Joe, like I've had cases where somebody goes, I went to the store and I walked out front and I slipped. And I'm like, what'd you slip on? Well, I don't know. Well, did anyone see you slip? No. Was there any ice? No. Was there anything on the floor? No. So there's not a claim I can support there, right? I'm hearing their story. And am I going to be able to tell that story to a jury, sure, with a straight face? Am I going to be able to tell it to the insurance company to say, Joe got hurt when he fell, but Joe also was wearing shoes with soap all over the bottom that he put on, right? Like if I can't tell the story like at the start, the first call, I'm thinking of, is there a way that I can put this person in a better position? And it doesn't have to be a giant case in the sense of, right, I don't think that justifies, like, justice doesn't just apply to somebody harmed severely and super negligently, but it's even minor cases where somebody has something small happen to them, but it upends their life. And so I'm thinking from the very start, is this a story that I can tell and I can support? Can I demonstrate their negligence, right? Car accident cases are a little different than a medical malpractice because you have to know who's at fault pretty quick. The police come out. Whereas when somebody gets hurt by a doctor, in case we've had, you have to prove it through another doctor. You can't, there's very seldom the medical investigators don't come out and say, that was negligence. And so from the start, it's just thinking of that story and how I can contextualize it to best put it forward to write. Can I even put this person's story forward? At the same point, that's led to a lot of people coming. Some of my best cases have been cases where another firm said, not interested.
Yeah, so there's some of the issues I see with attorneys are there's a lot of times a balance between in case presentations or and it's different from what I understand it in mediation versus arbitration versus trial, but the like you get this flood of data from discovery, you have to obviously figure out what you're going to present, what order you're going to present it, how you're going to tell this story to whomever, the mediator, the opposing counsel, a jury potentially. What do you like? How do you deal with that process? Because one issue that comes up, which is pretty predictable, is you have this sort of difference between emotional input, like information, like testimony from family members or friends or folks, and the scientific data. So like, what is, you have someone talking about how badly injured someone may have been, but then you have to juxtapose that with what does the actual report say from doctors. And how do you try to balance, like, not flooding too much one way or the other, like not looking too manipulative with emotional testimony, but also having to give enough scientific or medical information that it's credible? Like, how do you
Sure.
how do you handle that?
Well, I mean, I think, right, like it's like the human brain is wired for story. And so if you sit in front of a jury and you have a doctor who just lectures on like your most boring class you've ever been to, no one's going to understand that, appreciate it, or even listen, right? It doesn't matter how compelling. Well, I mean, it doesn't matter how compelling. It doesn't matter how straightforward or negligent that action is if the person talking about that is droll. Like right now, if I talk to an expert and they can't explain to me, right? I mean, I'm going to have to explain their words out, right? I'm going to have to learn from them to explain it. So if I can't understand them in our one-to-one, I'm not going to be able to explain that further. At the same point, though, right? I think people see the human side of it. I think there's as much as in the story. If I'm hearing this person, and I'm not like I have cases where my client has a negative past, right? And a defense attorney is going to bring that up, and so you have to be able to, I guess, thread the needle, right? It's again, make it compelling enough to demonstrate that they're in the best position to be taken care of by a jury or by an insurance company, and you have to demonstrate. First off, right, if you're going to get a settlement or resolution, you have to show the other side through the story you're telling that they need to settle, right? That's like most cases settle. You have to demonstrate to them that what happened is justified, that some resolution to your client is justified. And if not, you're going to have to present effectively a couple days long play of testimony about what happened, combating, right, if your client was a drug addict 10 years ago, that somehow contributed to them getting hit by a car today. And so you have to thread the needle of that story of, okay, you can't bring in 10 witnesses to say my client was really hurt that day and they'll testify to that, because again, it'll start to feel repetitive. At the same point, if you're just reliant, so I think it's striking a balance, right? In having any of that context, you can't just have one or the other, but there are some cases where that might be all that's available, and to best put your clients step forward and talk to them about how they're going to present their case, because they have to be on board, right? And unless the client is unfortunately passed and you're working with a family, the client has to be moving with you. And so them understanding the process of what's going forward, explaining to them that, to tell that story and kind of, I mean, thread that needle of scientific expertise. And also, I'll say, Joe, maybe not every case requires scientific expertise. A car accident happens. Sometimes it's in a position where I can just get their doctor to come in and say what happened. Sure, they don't need to say that the accident caused it, but just having someone to say, yeah, Johnny was really hurt is helpful. And you don't necessarily always need to have that heavy scientific backing. Sometimes people will understand, right? They'll recognize, and not everything has a huge scientific hook, right? The floor was slippery, they're hurt, their back's hurt, it wasn't before, is not often a big thing for people don't struggle to buy that, I guess, or understand that that's what can happen.
Oh, and that's a good balance that you're talking about striking, and you're dealing with what you have in front of you and the reality of the actual resources or opportunities you have versus probably your budget of, you can't hire 7 experts for every case.
Sure.
And you're going to go broke. But That's a good way of summarizing your strategy there. But the other issue I see is sometimes, and this is from storytelling perspective, is when you have like emotional witnesses or character witnesses or family or friends. How do you deal with like talking them through testimony in terms of like, yes, they need to talk about the emotions of it, but also like their actual observations, like because there could be really highly relevant things that they've just seen. And how do you deal with that when you're like in deposing family members or folks who know or coworkers or whoever witnesses? Like, how do you kind of go through that process to keep them talking appropriately, but without getting sidetracked or helping your opposition?
Well, so I think of oftentimes the plaintiff's case, there's not a lot I'm trying to hide. Like to be frank, right? I tell the client that we're going to put this forward, but we're going to have to put your medical records out there, right? We're going to have to talk about naughty like a tree, like the naughty parts of your life, like the right where people are complicated. So we're going to need to talk about that. And frankly, generally putting it out there, sure, Johnny had an issue in the past. That's what we handle. I think though, for me, it's actually a lot of the time, it's not, they call Joe for a deposition. Defendant will say, Joe, what'd you see that day? Joe, this happened. This like the observation is actually a lot more straightforward. Defense attorneys, that's all they want to pull out, right? You weren't able to, after the accident, you weren't able to garden every day. Those are the things that I think are really easy for people to pull out. I think it's like we'll think of the memory, and that's the question asked. I actually am trying to, a lot of the time, on top of that, I want to get that story out. How did that make you feel, right? How did not being able to garden ever again, how did that impact you? Because I think that's the thing that where I really like what I do, where I really recognize the value to people in what I do, in that, sure, you can put all your medical records up. Any person who's not a lawyer, I think, can say, here are my medical bills, pay those. That's not fair. And some insurance companies might say, yeah. I think the hard part then is what's the human loss, right? You're sleep at night, but are you sitting there every night just like in dread because of the TBI that you have? Are there parts of this? Are you not able to do the thing that brought you joy that you woke up to do every day, right? Like you're a journalist, if you can't write, like if you can't use your hands to write something, that takes something away. And so just the emotional side, I actually think is a lot more important to be pulled out, because I think that's the human side. Sure, you can't have a case that's just on emotion. Like I have people call sometimes and say, this happened and it really made me upset. And it's really hard to make a case just from that, right? If someone almost hits you with their car, often there's not much that can be done in those situations. But having that observation of how sure, I can't garden anymore, but then also that made me feel like I really lost, right? Like gardening gave me this growth in my life, and it allowed me to see something reborn every year. That's where I find the answers from people to be the most connecting, right? And I feel like sometimes it's like somebody gives that answer of what their emotion felt like, and like the defense attorney, I've seen some who are really aggressive turn that off a little bit, because I think they're like, oh wow, that's where they recognize a human is in front of them. Whereas the observations of the case can make it very much feel like we can read a story in it, or you can just read the facts left and right from both sides, but the emotion is kind of what gives, I don't want to say flavor, I think that's where it misses. If you don't have that emotional side of things, it can be easy for the other side not to recognize this is a person sometimes, but also to recognize how an accident, an injury impacted a client.
Yeah, and so you, having worked a little bit in the defense side, how does that inform you now? Like, what did you learn from that? Or are there any tricks that you learned that kind of changed the way you might have otherwise thought of being a personal injury lawyer? Or
Yeah, I mean, I think I don't know what I wouldn't have known. I do know that, and I found this like so many things in my life. Squeaky wheel gets the grease, and so if you are filing motions and doing things and making them making the defense attorney give you attention, they will, right? They often have plenty to do. And so if you're not doing anything and they're not making any movement in the case, they have other things to handle. And so if I can press the case along, get it started, get it filed, get it going, usually some movement is better than no movement. And so that's like the simplest thing is that they're busy enough doing other things that if you want your case to move forward and want to move for clients, you've got to be filing motions. You've got to be sending discovery. You've got to be remaining activity towards moving your case forward. I mean, sometimes I remember seeing cases like at a firm I'd worked at once, the case would be filed, but they wouldn't request a scheduling conference. So it had been 3 years with nothing happening, and then they get a trial date. So that would be 2 years down the road. So sometimes, I mean, sure, there's reasons that might occur, and I'm not saying that's necessarily bad. There's strategic reasons someone might do that, but just moving the ball forward, and at the same point, I try to be better about this. I mean, there's some folks you just don't get along with, but also it's like the relation of with the defense attorney. There's some defense attorneys that I can talk to. Right, we're going to argue, we're going to definitely disagree, but there's others who get on the phone with me and they talk to me like they're a robot, and it's like, well, we're just not going to get along because I try to have that relationship. But if we're not going to get anywhere, I do recognize having that relationship can be helpful. But at the same point, I remember being at a defense firm, and this plaintiff's attorney called my boss, and he hung up and he said, F and A hole. And like that was right then. So, and then he didn't work on he delayed things in the case related to him thinking that person. So I think you have to strike a balance. It's good to have that relationship, but at the end of the day, I'm not going to put that relationship with a defense attorney if it means if they're going to be obstructive, and some are just unreasonable. If they're going to be obstructive, I'm not going to be able to. I'm going to focus on helping my client at the end of the day. That's the relationship that matters the most to me, is helping them out.
So you're talking about, like, making sure you're staying on top of the case and you're filing the correct motions. Or I'm not a lawyer, so I'm kind of just freewheeling here. But in terms of storytelling, is there something that you can do during that process that moves the case forward? Because I've been brought in on cases myself where typically I'm brought in and the case has been going on for 2 years or so. And then there's an upcoming mediation hearing or something that they want me to make a video for. But what is there something that you kind of look at doing to kind of try to move things towards a settlement or speed things along from a storytelling perspective, or like for some of the non-lawyers that may be watching or listening, like what does that look like?
So from a storytelling perspective, I mean, I think even in motions, I just want to put out the story, right? In the motion, I want it like at the start of it, I'll say background in Joe's case. This is what happened to Joe, and this is like telling that, right? I kind of want my story to the defense firm to be out there immediately. But even in the context, if we're talking, I'm going to be like, I try to get on the phone with the defense attorney. This is what happened, right? This, like, telling them the story in the same context, how it's impacting my client. From a story building perspective, I think it's the discovery of having some of those, pushing to get some of that information out, right? Sometimes defense firms just don't want to disclose certain information, so I can't even tell the full story. So I need to know parts of it to tell that story. But that's also where, if I can get that, or maybe even a little early sometimes, doing depositions of folks. I don't think you can fully get to the part of the way I think of discovery is I'm trying to learn information, right? I can't know everything. And so it helps to tell that story. But that's, I think, the analogy I've heard that I like is that, like, a plaintiff's firm or plaintiff's attorney is trying to build a boat as the case goes along, and the defense firm is just trying to pull a piece out to sink the boat. And so you're building pieces on, and for them, it can be also, oh, look, I found this. You say Joe's back is hurt. Well, here's this photo of Joe carrying carpet up the stairs yesterday. And so, right, like that's an immediately, like, I've been building the story and I've been learning all about the negligence the other side. Well, we come to find out that Joe actually isn't that hurt. And so it's learning all those things to tell that story. But I think in the context of it, it's a process. When you come in, right, like someone like you to come in and do that in a case is probably closer to trial. I try not to think of cases as like setting up for trial or for settlement. I'm trying to push it in the best position for the client. And like I said, most cases are going to settle, but you have to do. I'm more likely to have someone like you in the context of, if this mediation, I really want to put that out there, or for trial. And so that kind of depends on the court scheduling, but I think that's more of the general process towards something. But again, at the very start, when I'm first talking to a client, I have to think, is this story going to make sense to people? Is this going to be something that a jury, right? It's a jury of their peers. Are they going to understand it? And so it has to go from there to telling that story to, like, there are times if a case goes on, I find out something, I'm like, well, this doesn't make sense to me anymore, right? And that kind of changes the context of what I can do. So all that to say, it's process, I guess, would be the answer to your question.
Yeah, and you made an interesting statement there about, you said it's not necessarily about building it for the mediation or the trial. It's about what's best for the client. What do you mean by that? Talk about that more. Like, what does that mean?
Yeah, so I think I've heard the phrase, "We prepare every case for trial." I don't think that's reasonable, right? I had a case recently. We settled within 3 months. Some severe negligence. Other person worked for an employee or an employer, attacked my client, and my client healed up decently quickly. We sent a demand. The client had a good understanding of how much they wanted from the case, what the value of the case was. We talked about it. It would have been unreasonable for me to start drafting complaints and discovery if I thought we could get to resolution. We're pretty close. But to build a case like that, to focus my energy on that and building it for trial would have been unreasonable for that client, but it's unreasonable for all my other clients. I try not to, and that's so I like setting it up for either, right? If I'm filing a lawsuit, I'm going to be willing to try the case. But a lot of the time, I don't have to be sitting there drafting my opening statement. I think there's like some bravado and there's some firms that have the benefit of only needing to take cases like that. But I'm not starting my opening statement when I file the complaint. I'm thinking of the story, right? And that's got to be in my head you're telling that story to a mediator, to a defense attorney, to an expert. That's got to be the case going along. And sure, there comes a point when you go, well, this is going to trial or not. But frankly, I tell people most of the time when a case comes in and we file, the likelihood of getting to trial in New Mexico on a best case scenario is 2 years, if even. And that's in state court. Sure, it'll go faster in federal court, but it's not going to go very quickly. So knowing things as they go along, right? And I want to put my client's best foot forward to mediate. And that's like the defense firms can make it very easy. If like you go to mediation, you're telling the client, hey, this is what we think the case is worth. It's worth $100,000, whatever the case may be. Defense firm offers $0. Okay, client, we're going to try this case. Like it's not a hard calculus. I think the harder ones are, and like there's some economics on this of like, they get pretty close to your point of view and the client's like, well, that's good enough. And they don't want to keep fighting. Again, having spent a lot of money on costs for a client who's in that position, who wants to resolve it outside of court and doesn't necessarily want to go to trial, that's not beneficial to them, because if I spent $10,000 in costs, well, that comes out of their settlement. And so again, having to be conscious of what happened. Sure, I've had cases where my client almost died and severe car accidents where we were ready to take bigger steps and spend higher costs. But it came to a better resolution because we were able to put the client's best foot forward. And so I don't necessarily think of it as preparing for a trial or for settlement. I'm trying to run the ball down the field and put my client's case in the best possible position. That totally is circumstance dependent in my position, though.
Great. And so when you have cases that do settle, again, this is coming from a non-lawyer sort of question for anybody, is like, when do they typically settle? Do you have to go through mediation and arbitration, or can it just be any time? And for you, what has been your experience where cases most typically have settled for you in the past?
So a car accident case, like I tell people, generally 6 to 9 months if your injury is resolved, right? That's probably the most important part. And we find insurance and there's enough coverage to, like, you have $25,000 in injuries and there's more coverage. Generally 6 to 9 months is reasonable. However, I have cases like that where that happened and the insurance company didn't respond. They refused to interact with my client, or they just said, you're faking it, really. And so the simplest answer, it can settle the moment the case starts to, right, like some car insurance companies will send a vehicle out to the crash scene and have people sign a check, say goodbye, claim's over. And it can settle until the jury brings a verdict. In my experience, my best case I've ever had a settlement for, we sent a demand not thinking it would settle, and it settled. We were able to mediate. We mediated before trial had even been, right? The other side didn't want this out in the public. Whereas I've had other cases where it gets really far down. I think I'm like, this is pretty straightforward and clear, and we get close to trial, and that's what it took was showing that my client was willing to stand up. So it can settle at any time. Settlement feels like mediation makes it feel like it has to have a mediator. There's some defense attorneys I like working with because they're willing to, we don't need to spend $1,000 on a mediator. We can have a conversation and hopefully find a number. And so any time is possible. But right, generally my experience, if you're not going to send a demand, a defense attorney is not going to do anything. They don't, I don't know why. And maybe I've heard some people say they don't want to insult a plaintiff or a number of reasons. But a lot of the time defense attorneys are not going to put out an offer. And I don't know why it depends on the person for the motivation. So plaintiff's attorney have to oftentimes say, here's what we're willing to settle for. And sure, I tell clients all the time, this is what our demand is. Are they going to come up to this number? No, but that might be an indication of whether or not is that the real number they want to resolve on, or are we going to trial, right? It allows them to kind of make decisions as we progress along to get to a number to decide what we want to do.
The case you mentioned where you said you had a really substantial settlement that it sounds like early. Why do you think it resolved early for a substantial amount? What was it about that demand letter or the presentation, or was it just the strength of the case, or why do you think it would achieve that result so quickly?
I think first off is that they recognized how it happens that the defense will go, wow, that was bad, right? Our employee was acting so dangerous, our insured was acting so dangerous. And to be frank, it was I think them recognizing how negligent the actions were. At the same point, it was us we had gotten some experts to do a reconstruction. We had gotten some opinions on it. They were able to early disclose the footage, which kind of proved our theory of the case really early. And to the benefit of the clients, right? The challenge is and I think they were thinking too, this would have been a case that would have been substantially dangerous to them, right? If we go to trial, it would have been a large verdict. And we had some studies and some focus groups done that supported this. And so getting to a settlement allows the client not to take the risk of a number of years of litigation, right? Even with a great case, it's still possible to lose it. At the same point, the defense firm doesn't have this potential liability on their books for the next few years and fighting this big battle that I think it would have been a PR nightmare for them. So that's why. But again, this is a case that I had that two firms had turned down. So you never know what's going to come in, and I think they came down that the client was also incredibly sweet and very kind, and so those are all things that shone through. And so it can depend on so many factors that it's hard to tell. There are some cases that I've had where the other side, unfortunately, has had some practices that are pretty clear to see that if a person is a certain race, they're less likely to settle a case, right, based on how they think they'll present to a jury.
Yeah, that's really unfortunate to say the least. Why do you think, or did you know why the other law firms had turned that case down? Or
no, that was
why you accepted it?
Why I accepted it. The client called, and it was the first time we talked. I could just tell, we connected in the sense of it's a relationship. And so, the first call, I was I had a feeling that it was going to be. She told me what happened, but again, it was just one of those things where I still reach out to this client periodically after we resolve to check in and see how they're doing. But I think it started there for me that I'm okay, this is going to be a case for me to take. Why wasn't it taken? I think the firms that didn't take it, which are both well-known firms, my client survived, and some firms only take cases that are deaths. And I think I try and think of it from the other end of the client side of point of view, and that they're looking at a case like this. Something bad happened, something awful happened, but it's hard for them to know, right? It's hard to know what the legal system looks like. There's benefits to it looking overcomplicated. Some people, it keeps people out from protecting themselves, but also I think that her surviving for some people didn't look as concerning. Some firms only take wrongful death cases, and so that was a negative to her. At the same point, there were parts of it that I was okay, whatever we can do, this is a case I can make a positive for you and put you in a better position. And so I don't know why they denied it, but again, I took the call and was I think that I can do something for you. And so that was one of those cases. That was one of the ones that I'm proudest of, not necessarily for it being my best resolution, but again, it was somebody who I developed a relationship with, who I care for. And that's what I hope to do, right? I hope to create a relationship that's caring. I do this because I care about other people. And so having that just felt I knew immediately we connected, and having that and getting into that position was just so that's the feeling I'm chasing, right? Putting somebody from something awful to putting them in a better position and being able to stand up for themselves. That's the sweetest joy in what I get to do.
Great. And so this is kind of bringing it together. This is kind of a big question because,
Sure.
So we're talking about a lot of different things here, but how do you handle case presentation for different sort of venues? So there's one, it sounds like there's a case presentation of you just straight up talking to defense counsel over the phone or via email. Yep. There's also the, dealing with a mediator in an actual mediation hearing. There's actually going to court. How do you present your case in those different venues and what, if anything, is different about how you present those cases? Because like I'll make like a settlement demand video for somebody in a typically a hearing, but there's all kinds of ways of of bringing things up. Like it's documented. Is it like a PowerPoint kind of presentation? Do you actually like fly in all the different witnesses in person, or how do you handle those different venues? It's a pretty big question, but how do you bring it all together when you have to?
So I think it first starts for me, like again, if you ever see me driving on I-25 and I'm talking to myself, it's because I'm maybe in my head just like getting that story out there, right? It's starting to tell there, and thinking through the ways I'm not necessarily getting to where I want to, or the mistakes I'm making. And so it's all three of those venues are similar and also different. Sure, like a defense attorney, they're never going to buy my argument because some will just assume that that I never turn away cases and I file every case that comes in the door. Is what it is. But I'm sure I'm not going to, I'll tell them about what's happening, but some people just won't buy it. And so it's still, I think that's more of talking, hey, you've seen cases like this. This is being more honest of the lawyer side of things. In mediation, it's often helpful. It depends on who the mediator is and what story they're going to tell and their background. A lot of times I actually prefer a mediator who's been a long time practicing attorney, because I think they're going to have seen a lot of things. They're going to be in a position to go, I've seen a case like this, or this is the risk to the other side. And they'll frankly be in a position to tell my client. Sometimes having them look at it from another perspective is helpful to the client, or is helpful to me to go, oh, there's a piece of our case missing. I think building it, though, really comes down to, like, sure, I think a PowerPoint is great. I think even just a flip chart of writing on there in front of a jury, I think neither of those things are going to be in the context of a mediation or just a call with a defense attorney. I think the production is bigger, right? There's bigger components of, I don't want to say scripted, because I'm not trying to script everything I'm saying, but having the whole thing laid out of who I'm presenting, right? Organizing. It's my dad used to be a drama teacher, and I think of this is a similarity between our roles. It's that, sure, the play is important and everyone knowing their lines is important, but sometimes the most important part before that is making sure that witness Joe is there. You not being there is really detrimental to me having, like, there's no point in me preparing for your cross-examination or your examination if you're not going to be there. So it's like, first, it's just getting everyone there, ordering the parts, making sure we're filing the basics, like the trial subpoenas, right? Those first steps. And then from there, it's building the bigger story of how we're going to, in some cases, the story might be better if I have the client not in the case or not in the courtroom, right? It's totally circumstance dependent. A trial is just so, I think similar to a play is a great way to think of it, because you might have a different backdrop based on the play. You might have, I am more likely to have in a medical malpractice case, some kind of demonstration of what the procedure or what happened, because not everyone works in an OR. Whereas in an accident, I don't always get a scene reconstruction, because plenty of times the police found him at fault. We have video footage of the accident. I don't need those things. And so I think the creative aspect that I like is I need to be willing to look into my toolbox and think, like sometimes the job is just to sit back and think of what's a different way I can demonstrate to the jury of what happened to Joe and how this impacted Joe and his life. And sometimes, like you said, like a day in the life video is great, of saying Joe would have been doing gardening today, or and I'm thinking of that because I was doing that earlier today. But having that context, building that in, just really a lawyer answer of it depends, but kind of how you can best put forward what happened to somebody and kind of what they've lost, and then sometimes too, the hope is to build in hope of what a resolution can get for them. Sure, there are cases where clients never going to recover from this. But in that case that I really liked, the client had done some impressive things and had fought through everything, and their goal was to get back to dancing, and like they had endeavored for 2 years to get there. And so having that hope and demonstrating what they like, right? Like that indomitable spirit. I think people love I think most good stories involve some component of an indomitable spirit. I think of like stories of like climbing Everest, right? Like you can have that moment of showing, not only did this terrible thing happen to them, but like perseverance. I think if you can build that in, I think any good book I've read shows the hero like fighting through adversity. And so I think that like helps to build that in there. But I think that relates to, and I think that relates though to the defense attorney, to the mediator, to trial, building in to show, right, my client's still standing up for themselves today. Despite all that's happened, they're standing up for themselves. And so I think it's really important to show that because, frankly, that's when I'm talking to people. And if they say, I think a quick way to show that a client doesn't have that is if they refuse to get medical treatment or like I've had people who I had to dismiss the case, like I'm really hurting, and they don't go to the doctor. When I set them up for the doctor, I call them. They don't answer my calls for weeks, and so I think those are the cases, right, that I look at and I go, okay, we aren't going to take that. And so building that in throughout the context is kind of my goal, but again, the circumstances definitely depend and can shift where you go.
Good. And so we're kind of getting closer to the end here, but the like last one of the last couple of questions I always ask everybody is just what is something that really has kind of zinged you that the defense has done, or something that like you feel like can throw you for a loop, or that you learned from in the past that was really challenging that maybe you've had to overcome, or what has that been like for you?
Really zinged me. I mean, I think it's I think the one that always zings clients and can be hard to take even when you know it's coming is when they blame whatever happened. Like, and that's more common maybe it can happen in a car accident case too, but it happens a lot in medical malpractice. Well, no, the doctor didn't harm you, you harmed you. And I think that's one that really hurts because first off, the client is brave standing up for themselves, but it does feel hard to get that pushback. And then for me, even expecting it, it's always frustrating because it's like, well, we both know enough to know that, and that's kind of their story they're telling. But that hurts, and I think that one of those things I try to tell people early on is if you're going to take this path and we're going to go on this journey, you have to recognize that it's likely that despite the fact that we have video footage and they're going to say that you're just money hungry, that you caused this, that you're at fault. And so I think even in the context, like I think it zings because it's like you recognize the human side of things. But again, my hope to combat that is I tell people early on, if you're not okay with someone telling you that, right, you have to believe your story at the end of the day. And we've seen the video, we know that's the case. If you don't believe and aren't willing to push back and say that's not how I recall it and that's not how the video shows it, then I think that's really going to make a case really hard. If somebody can't go through that, that's not a case that's going to be set up well for trial, right? And so I think that hurts because you care about these people and you care about what happened to them, but at the same point, it also justifies the fight further of, okay, well, let's show them what happened to you and let's show them what you've done to persevere and make yourself better and fight to do every day to get better on top of what happened to you.
Okay. And then the last question I always like to ask everybody is, and then, if you look back on yourself before you even became an attorney or back on yourself in law school, what have you learned so far that may have surprised that person or someone else outstanding outside of this whole field that is really maybe notable for you? Like, what is something that other people don't that you could share? I mean, or even if is there anything like that? Like, what could you it's a corny question,
Sure.
but kind of like, what would you tell yourself as a young man, like, that you learned?
I mean, I think that like in the context, my hope is that my job in order to be successful, I have to persevere. I have to fight through people disagreeing with me. I have to fight through that. And my hope is that I show that and I have those fights and I show to clients that it justifies them doing so. But I think that, if I'm talking to myself before law school, I never imagined I'd be out on my own having a practice. I think the thing that is like really incredibly like gratifying on top, like I talk about that feeling I chase, but it's incredibly gratifying. I went and started my own firm. It was incredibly gratifying to have clients go, okay, I'm going to trust this guy who's going out on his own, and to have some of those people already being like able to resolve cases for them and show them, hey, I don't know what the other firm would have done, and I like no disrespect to them, but I feel pretty darn good about what I was able to do for you, and I like thank you so much for trusting me. To tell myself that I'd be in a position 10 years ago when I started law school or so to not only build that trust, but justify to people why I've developed skills and I know what I'm doing to help them, is just very satisfying. Again, makes me just want to get better at what I'm doing, right? I don't think I see the people who are on LinkedIn who are 25 years down the road talking about getting better. And I think it's like that chase of like that idealistic reach of can I get there, right? You're never going to reach that ideal of where you want to go, but I think it's pretty satisfying to know that I can still get better and seeing other people do so. And so that's the part I look back on of I would have never expected to have my own firm or to have built that trust. But then I think also the thing that's kind of exciting you built all those things and you've justified it, and then but now go out and prove it some more. You kind of keep proving it every day. So yeah, sure, it's corny, but I kind of like the question, Joe. It's nice to I do this because I care about people, and so being able to put them in a better position. And hey, like, right, I had like a case once where the guy was like, I can pay off my house. That was just so satisfying, because sure, should he have ever had to go through what he went through? No. But being able to make the situation better for somebody is just fantastic. So
Great. And is there anything else that you want to add that you really wanted to get off your chest here? Or?
to get off my chest. So this is just aimed at attorneys generally, right? Or is it aimed at more plaintiffs' attorneys?
Kind of just, I mean, we'll see who it ends up attracting. You never know.
Sure.
Because but it's probably more aimed at a legal audience. But I definitely like to make sure if anybody listens or watches that they can at least understand it, and they're not like kind of bewildered halfway through it if we start dropping a bunch of terms that they don't understand.
Yeah, I mean, I think my hope is of doing what I do is to connect with people, build those relationships, and care for them. I think that anybody who, I think, was it like any, as a good, to build trust, you need to be someone they know, people they like, and like they're aware of. And right, my job requires a lot of awareness, but my hope is that I can build relationships with people and help establish them. And I think that, like, if you're looking for an attorney, you got to be able to talk to that attorney. You got to be able to connect with that. And it's crazy to me how often I get a case and they'll be like, oh, I had an attorney, but I never talked to them. And sure, you can't talk to them every day. And if a client expects to talk to an attorney every single day, I think that's unreasonable. But for me to tell your story and build a relationship with you, I need to talk to you. I need to get to know you. I need to learn about you. And so that's the thing. I don't know if this is for people in the non-legal audience or who are non-lawyers. That's what you should be looking for. And at the same point, my hope is I've been really happy. I really like what I do, because I see that most plaintiffs' attorneys just want to build that relationship and recognize that I'm going to go to your house and I want to let me learn about what you got going on so I can better understand you. So no, past that, I don't have any pithy wisdom. I think you can follow me on LinkedIn if you want my pithy wisdom from time to time. But yeah, thank you for the time, Joe. I appreciate it.
Thanks a lot for stopping by. It was great talking to you. Thank you so much. That was Damon Hudson, personal injury attorney in Santa Fe, New Mexico. Thanks again to him and to you for joining me on Make Your Case. If you enjoyed this episode, hit subscribe so you don't miss what's next. If you're a legal professional looking to present your case more powerfully, whether it's for mediation, settlement, or trial, check out cleareyedmedia.com. We help lawyers turn complex cases into compelling video stories that get results. And if you're an attorney with a case or experience that could make a great podcast episode, I'd love to hear about it. Email me at joe@cleareyedmedia.com. Thanks again for joining me.